Some of you may think you're peace officers 24 hours a day. There is no legal basis for that concept. The California Penal Code gives you peace officer status anywhere in the state, but that authority is severely limited when you are outside the geographical limits of your department. Also, your employer's liability coverage for your negligent or intentional acts may well stop at the city limit sign or at the end of your watch. This show contains several vignettes which will depict a police officer in various on-duty and off-duty situations. We will ask 3 questions at the end of each vignette. Can the officer be sued for what he did? If he can be sued, will he have to pay for his own lawyer? And finally, if he loses the lawsuit, will he have to pay the damages himself? Before we answer these 3 questions for this episode, we should know a few general rules. Number 1, you acting as a police officer can be sued for your negligent or intentional acts. Number 2, the public entity you work for will be financially liable for these acts when performed within the scope of your employment, which simply means job-related or job-connected. The public entity does not have to assume liability if your act involved actual malice, actual fraud, or corruption. Now, what does this mean exactly? It means that the public entity you work for must pay your defense in all ordinary damages resulting from the lawsuit, such as medical bills, loss of employment, and similar financial losses. If you acted intentionally, punitive or punishment damages are often assessed, and these you personally must pay. So keep these 2 general rules in mind as we proceed through this show. You can be sued for your negligent or intentional acts. The public entity you work for will be financially liable for these acts when performed within the scope of your employment. The officer was patrolling his assigned beat when he had the accident. If he had not been negligent, neither he nor his public entity would be liable for any injury or damage that resulted.
Hi, I'm Bob Hale, and this is Dolly. That's a studio term. Actually, Liz. Liz is going to be my Dolly. She'll be helping me remove the cartoons. Dolly, you may remove a cartoon. Isn't she fascinating? Now, Officer Miller has a problem. He is worried. The problem is very simple. Will I be sued? Number 1. Number 2, do I have to pay a lawyer? And will there be damages that I will have to pay? Well, now, it is very simple. Officer Miller is under the scope of employment in this situation, scope of employment. I will not say what's going to happen to him when he gets back to the station, because the sergeant is going to be a little unhappy about the whole affair. But to explain it, well, because even though he was technically still in the scope of employment, patrolling his assigned beat, thus Officer Miller can be sued, but he will not have to pay anything out of his pocket. Now, when it comes to a Code 3, well, that's something else again, because under a Code 3, there is a difference, even though good old Miller went out and knocked over a fire hydrant, which will make the fire department very unhappy, and possibly he'll kick out a corner of a building. He might even take and sprawl a couple of Boy Scouts out on the street because, well, Officer Miller is sort of Officer Miller. The public entity will pay for his defense and damages. On a Code 3, however, he'd be protected from even being sued by a special code section. The public entity could still be sued, however. Now, let's take a look at Officer Miller's next goof.
The scope of employment can be thought of as any act that is job-related. Officer Miller was certainly performing an act related to his job at the time he negligently collided with the other car. But what if Officer Miller committed an intentional act, such as battery?
I think everybody is familiar with the irate citizen that comes along with a bit of a temper. Every police officer has met this fellow. It is fine, it is dandy. Yes, that's just part of the job to meet this fellow, but let me remind you that in a case like this, a police officer should use only that amount of force necessary to overcome resistance to arrest. That does not mean, for goodness sakes it does not mean, pow in the kisser. Because if you haul off and do something like this, we are back in trouble again, as is the case with our good old Officer Miller. And you can bet that the citizen is going to sue. Now, Officer Miller intentionally injured the citizen while legitimately trying to arrest him. Who's going to pay for Miller's defense and damages? The public entity. Why? Well, because Miller was acting in the scope of employment, and this will make the citizen very happy, of course, because there are punitive damages involved, provided, of course, that the court assesses punitive damages. So, regardless of the situation, the officer may be stuck. The city, the county, or the state will defend him and will pay for damages, but Miller still pays punitive damages if assessed by the court. Now let's go to Mr. Miller's next goof.
Officer Miller is going to make out a routine crime report. But while making out his report, he happens to notice a friend of his who owes him $30.
Hey, Miller, how are you? Haven't seen you around.
Hey, you guys got robbed.
Yeah, we did earlier this morning. I wasn't here, though. I don't know what happened.
Well, I came here to take a report, but I also want to talk to you about that $30 you owe me.
Oh, yeah, well, you haven't been around, or I'd given that to you a long time ago.
Yeah, I'd like my $30 right now.
Huh? You came at a bad time, Miller. I haven't got the money right now.
I want the money right now.
Well, I haven't got it. You want me to steal it out of the till?
Hey, listen, I know you can come up with the money right now.
It's July, isn't it?
Yeah.
I'll give it to you about Christmas time.
Hey! Now we have Officer Miller on duty, and this is one of Officer Miller's buddies. The buddy owes Officer Miller $30. Obviously, the buddy doesn't have $30. This makes Officer Miller extremely unhappy. Well, let me explain this situation. He is not protected under this situation, under the good old scope of employment rule, because he was conducting his own private business. So you guessed it. Naturally, Officer Miller has to collect his $30 by the use of, as we know it, assault and battery. This is the fellow who owed the $30. What's the situation here now? Well, he's trying to collect his $30 with the help of assault and battery on his buddy, but collecting a personal debt is hardly considered under the scope of employment. You see, Officer Miller now is in deep, deep, deep trouble, and he should be after all of these lawsuits that are happening to him in one day. When it is not under the scope of employment, then he is liable to have to pay lawyers' fees, court costs, loss of income, hospital fees, and good old punitive damages. Now let's see how Officer Officer Miller gets into his next mix-up.
Officer Miller is now off duty and within the geographical limits of the department he works for. What if Miller became involved in some police action under these circumstances? For instance, what if Miller saw someone with his hand in the till, and while attempting to prevent the crime, he injured an innocent bystander? In a later suit by the injured bystander, would Miller, or would the public entity he works for, have to pay for Miller's defense and for any resulting damages? In other words, is an off-duty police officer within his employer's jurisdiction acting in the scope of his employment if he engages in law enforcement activity.
We have another 2, please. Hope we've got a nice house tonight.
Yeah, the night's never gonna end, though, I'll tell you.
Band's pretty swinging.
Yeah, it's pretty good. Hey, what are you doing? Oh!
Well, now, here goes Officer Miller again in hot pursuit of the suspect. Except this time, Officer Miller is so anxious, he stomps all over the stomach of this broad. I think Liz is cuter. Let me take the card. She gets me all shook up. Now, the problem is that Trixie LaRue's boyfriend happens to be an attorney, and one of those kinds of attorneys that chases ambulances. And naturally, he's right in there getting the witness list all set to go. The situation is here. Is this going to become, does the city assume liability? Well, sometimes yes and sometimes no. Now, that doesn't tell you much, but let me explain it. Officer Miller is in a quizzical state now, wondering. In Los Angeles, it's the city attorney who decides. The city attorney considers each case individually before assuming liability for an off-duty officer's act. In Fresno, on the other hand, they routinely assume liability if it is in the Fresno jurisdiction. So your best bet is to check your own situation, your own liability, wherever your jurisdiction is.
Officer Miller is now in the position of being an off-duty police officer within the jurisdiction of his public entity while working for someone else as a security officer. Public entities generally agree that an officer may not be considered to be working as a peace officer for 2 different employers at the same time. Thus, when Officer Miller is employed in a second job involving security duties, he is outside the scope of his public employment, and the public entity is not liable for either his legal defense or for damages. All is not lost, however, because Miller can look to his private employer in the event of liability caused by his negligent or intentional acts.
Now, naturally, if there is a fight, Officer Miller will have to get in and break up the fight. Well, this is, as you know, not Officer Miller's day. And as he takes a long swing, he glances off the jaw of a fellow who has nothing to do with the battle, and you guessed it, he probably is going to get sued. Well, what Officer Miller did, he forgot to get a contract with his employer stating that the employer would be liable for possible damages. So now Officer Miller is really in trouble because in this particular instance, well, he is not going to get any help from anyone. You see, Officer Miller carried no liability insurance, and the city attorney told him a bouncer definitely is out of the scope of city responsibility. So Officer Miller is in trouble again. Officer Miller now decides, well, now I'm going to give up this business of bouncing, and I'm going to take up work where I'm not going to get into trouble. I'm going to become a guitar-playing policeman and a singing policeman. This is just dandy, but between you and I have a hunch he's going to get into trouble again.
Officer Miller knows that the California Penal Code gives him authority to act as a peace officer anywhere in the state. But as we have said, peace officer authority does not necessarily carry with it liability coverage. There's no question but that Officer Miller is covered by the public entity while he is on duty and acting within the scope of his employment. But when he is off duty, inside or outside his department's jurisdiction, his liability coverage depends upon the policy of his public entity. As you can see, Officer Miller's situation, here as a non-security employee, is the same as when he is off duty, on his own time, and takes police action.
Well, Miller has done it again. He dove into a crowd, and he came up with the good guy. The bad guy got away, naturally. That's Officer Miller's luck. And, of course, the question comes up now, what happens to Officer Miller? Well, now, Officer Miller is going to have to face still another lawsuit, probably. Or, I should say, well, maybe. It all depends upon the case. The case is the thing that is going to worry Officer Miller now, because after this, which amounts to about the 5th or 6th lawsuit of the day, he's before the judge. Well, it depends. Was the good guy hurt? Had Miller been drinking? Now, here again, in some areas, the public entity would defend Miller, but in other areas, it may not. So your best bet is to check with your city attorney or county council. Miller should actually have caught the bad guy, then he'd have been a hero. Well, hello there. Thank you very much, my dear. Very much. So now let's take a quick look at the federal problems that could stick Officer Miller after the state's done with it.
Officers can also be sued under the Federal Civil Rights Act. The plaintiff is protected under federal law against unlawful arrests, unlawful detentions, unlawful searches and seizures, denying access to counsel, excessive force, or any other civil rights violation. And regardless of what happens in a state court, action can also be brought in federal court. Generally, the same laws that apply to the public entity in providing legal defense and damages in state suits apply to federal suits. Some other points. You are immune from malicious prosecution actions in the state courts. But because state immunities do not apply to federal violations, you could be sued for malicious prosecution in federal court. False arrests and false imprisonments form the basis of many suits against police officers in both state and federal courts. But these acts are generally performed in the scope of employment. Thus, the public entity will bear liability for your defense and damages. Now, what have we learned? If you are negligent while in the scope of employment, the public entity will provide you a defense and pay ordinary damages. While in the scope of employment, if you commit an intentional act, such as battery, the public entity again will provide your defense and pay ordinary damages, but never punitive damages. By law, a public entity cannot pay punitive damages. If you're in a private incident unrelated to your employment, you're on your own and must pay defense and damages out of your own pocket. When working on an off-duty job as a private security officer, such as a guard or a bouncer, this is also considered not in the scope of employment. Therefore, be sure to check and determine that either you or your employer carries ample liability insurance coverage. If you attempt to prevent a crime while working on an off-duty job that is not related to law enforcement, you may or may not have liability protection from your public entity, depending upon its policy. But even if you act within the scope of employment, but were acting with actual malice, actual fraud, or corruption, your public entity is not required to cover you in any way. You can also be sued under the Federal Civil Rights Act for depriving a person of his constitutional or federal rights. Even though the law gives you peace officer authority anywhere in the state, your public entity might assume liability for your acts only during on-duty hours and within its own geographical limits.
Say, don't I know you? You're Officer Miller, Officer Miller.
Hey, do I know you?
Yeah. You're the one You stepped on this waitress's stomach and you hit the wrong guy. And...
Hey, now, wait a minute. You're the guy that keeps drawing all them funny pictures about me, aren't you?
Yeah. You must owe more money than the national debt now with all those lawsuits. Oh, boy, that is funny. You're a real clown, Dad.
Hey, listen, you can't talk to a police officer like that.
Remember, scope of employment. Scope of employment. So long, Mac.
Hey, give me another beer, will you?